Recently, I had a number of people send me some articles about a case in Alberta where a Indian student visiting Canada was found guilty after trial of a serious sexual assault and was given a discharge because of his immigration status. So I thought, having looked at that, it would be a good time to revisit the issue of race-based sentencing in Canada. I've talked about this in the previous episode, but it was mixed in with some other topics, so I've been meaning to do a follow-up episode where we look at it more directly, so we'll do that today. Hello, my name is Nicholas Wandsbutter. I'm a lawyer in Stratford, Ontario, Canada, and welcome to Don't Talk TV. Apologies for no episode last week, just real life really happening to me, and then my volunteer PR guy, he had a death in the family, so just there's too much on our plate to put out an episode, but we're back and we're going to try to limit missing weeks as much as possible, but sometimes it's just unavoidable. So the case that first got me thinking time to return to the topic of race-based sentencing in Canada was the case of a Rajbir Singh in Alberta. And we'll have a look at that case, but first I want to look at the criminal code provisions specifically that relate to race-based sentencing and how a sentence should be reduced if a member belongs to certain races. So I've looked at that previously. Section 718.2, Other Sentencing Principles, is the section that's pertinent to this. It says that a court that imposes a sentence shall also take into consideration the following principles. Talking about increasing or reducing based on aggravating and mitigating factors. But what I want to go down to here is sub E, that the court's to consider all available sanctions other than imprisonment that are reasonable in the circumstances and consistent with the harm done to victims or to the community should be considered for all offenders, with particular attention to the circumstances of Aboriginal offenders. Now, today we'll take a bit of a closer look at some of the case law relating to that section of the criminal code. So we'll look firstly at what the courts have said about the Gladue principles, which Gladue being the leading case that interpreted this law. We'll then look at a case that talks about how this applies to non-Indigenous people, because as you saw, the criminal code specifically references Indigenous offenders, but it's been expanded beyond that. And then we'll finish out the episode with a look at that Rajbir Singh case. So the first case we have here is a recent Superior Court of Ontario decision, His Majesty the King and Moreau. As always, the link to this case is in the show description. And if we skip down to paragraph 44, there's a nice summary of how section 718.2 sub E applies and how it's been applied and interpreted by the courts. So it says here that in 1996, the Criminal Code was amended to codify the fundamental purpose and principles of sentencing. One of the provisions was 718.2 sub E, which provides that the court should consider all available sanctions other than imprisonment that are reasonable in the circumstances, with particular attention to the circumstances of Aboriginal offenders. And this amendment was grounded in a concern about the overrepresentation of Indigenous people in the Canadian criminal justice system. So Gladue was a decision from 1999 from the Supreme Court looking at section 718.2 sub E, and the Supreme Court confirmed that this signaled Parliament's intention that the sentencing of Indigenous offenders was to be undertaken differently than other offenders in order to achieve truly fit and proper sentences in the particular circumstances of each case. So this different undertaking of sentencing for Indigenous people is clearly, in my view, race-based sentencing, because Indigenous people, they have a different sentencing regime than non-Indigenous people. The court says that an altered method of analysis was necessary to give effect to what the court described as, quote, the tragic history of the treatment of Aboriginal peoples within the Canadian criminal justice system, unquote. The court in Moreau went on to summarize that the intent of the altered method of analysis is to address the unique circumstances of Indigenous offenders in the criminal justice system, the serious problem of overrepresentation, and the unique systematic or background factors that may have played a part in bringing the particular offender before the courts. Now it says at paragraph 48, an application of the Gladue principles does not, of course, immediately translate into a lower sentence for an Indigenous purpose. What those principles do is provide significant context in which to evaluate case-specific information about the offender provided to the court at the sentencing hearing. Now I have here an older case from the Court of Appeal of Ontario, Her Majesty the Queen in Hamilton, and this talks about how do those Gladue principles apply to non-Indigenous people. If we look at paragraphs 133 and following, the court stated there that the fact that an offender is a member of a group that has historically been subject to systematic racial and gender bias does not in and of itself justify any mitigation of sentence. Lower sentences predicated on nothing more than membership in a disadvantaged group further neither the principles of sentencing nor the goals of equality. A sentencing judge is, however, required to take into account all factors that are germane to the gravity of the offense and the personal culpability of the offender. That inquiry can encompass systematic racial and gender bias. They then quote the same court, Ontario Court of Appeal, in a case called Board, where they said, however, the principles that are generally applicable to all offenders, including African Canadians, are sufficiently broad and flexible to enable a sentencing court in appropriate cases to consider both the systematic background factors that may have played a role in the commission of the offense. Reference to factors that may have played a role in the commission of the offense encompasses a broad range of potential considerations. Those factors include any explanation for the offender's commission of the crime. If racial or gender bias suffered by the offender helps explain why the offender committed the crime, then those factors can be said to have played a role in the commission of the offense. So I think we can see from those decisions of the Ontario Court of Appeal that there is, in fact, different sentencing considerations and an entirely different sentencing approach when it comes to Indigenous people, but broadly speaking, for non-white individuals, there is a different consideration of sentencing. One can argue one way or the other whether that's appropriate, but I think the bottom line is it's clear that there is a different set of sentencing principles at play depending on your racial background. Because it's also clear that white people can never claim systematic racial discrimination as a factor. Whether one agrees or disagrees that whites can be victims of systematic racism, the fact is that our system, I think everyone would agree, says that white people cannot suffer systematic racism, and everyone's experienced examples of that and how that came into their life. So I anticipate that that's not a controversial statement, without delving into whether that's good or bad or right or wrong. Now, aside from section 718.2 sub E, there's another consideration when it comes to immigration status, which isn't strictly speaking racial, but when we look at the percentages of where people are coming from in entering into Canada, it becomes more of a racial thing because it's almost all non-white people, as we've covered in the previous episode. So that brings us to the case of Rajbir Singh, very recent decision from the Alberta Provincial Court. This is a case where the issue was determining a fit sentence for Rajbir Singh, who committed a brazen yet minor sexual assault in a crowded nightclub, and the appropriate weighting of collateral immigration consequences. So, as we will see, the judge gave Mr. Singh a conditional discharge, which means he was not convicted. So the judge found him guilty, the judge found that he did it, but no conviction, no criminal record, if he completes the 3 years of probation successfully. So let's look at the facts here. The victim was a 18-year-old person, KH. She and her friends went to a nightclub in Calgary. A couple hours after arriving at the nightclub, KH was standing at one of the bars waiting to order a drink when she felt a hand on her back. Initially, she thought nothing of it, thinking one of her friends was behind her, but then the hand traveled down her back, touching her buttocks and vagina. Wheeling around in shock, she saw the hand was Mr. Singh's. Before she could say anything, Mr. Singh again grabbed her vagina. KH blurted, "What are you doing?" and Mr. Singh walked away. The assault lasted a matter of seconds, perhaps 5 seconds. Now, a pre-sentence report was prepared. At the sentencing hearing on October 12, 2023, the Crown said that denunciation deterrence required 15 to 45 days of real jail. Defense counsel didn't even ask for discharge. They asked for 3 months of house arrest, followed by 18 months of probation. However, subsequent to that, an immigration opinion letter was filed, stating that if Mr. Singh is convicted of sexual assault, he would be subject to a removal order and deported with no right of appeal. And if he's discharged, he'd have an admissibility hearing to determine whether a removal order should be made. He's here as on a student visa, and then apparently turning that into a work visa because he didn't like school. They have a bit more detail on that here, paragraph 17. He entered Canada in 2018 on a 4-year permit to study at York University. Didn't enjoy his studies at York, moved to Calgary. After his study permit expired, he got a visitor permit, and then he's trying to get a work permit. His short-term goal is to start his own painting company. Now, I find this interesting that it indicates Mr. Singh had a privileged, supportive upbringing. So this is not a case where this person would be sent back to a war-torn country where he'd be subject to some sort of persecution or torture, as can happen in some places. This guy would be going back to a privileged situation and a supportive family situation back in India. But the court notes that it's appropriate to take into account collateral immigration consequences, as long as the sentence imposed remains proportionate to the seriousness of the crime and the degree of responsibility of the offender. Which in principle sounds good, but the way this is applied is interesting. So they talk about some of the factors that are to be considered in sentencing. The court notes that all sexual assault offenses are serious and invoke the primary sentencing objectives of denunciation and deterrence. However, the court found that this was at the lowest level of seriousness. I mean, I don't see how the judge can say this. I mean, you can get a lot less serious in terms of sexual assaults. I mean, an unwanted kiss, an unwanted hug. I've defended cases like that. Those are at the lowest end of seriousness, and even those, it's nearly impossible to get someone to discharge. So I find this quite remarkable to say that grabbing a young lady by the vagina twice is at the lowest level of seriousness. That seems more invasive to me than that, but the court says this was an impulsive act. I mean, I guess that's somewhat less serious than a premeditated. So then the court talks about the devastating immigration consequences, but that's the only reference to what those devastating consequences would be. I mean, is the court saying that just being sent back to India, even to a privileged and supportive family, is devastating? The court then looks at a similar case, Safarpur, who is an Iranian immigrant. He pled guilty, which is clearly showing of remorse, had undergone counseling, but had also committed a sexual assault in public on a stranger on the LRT, and he was granted a conditional discharge. So therefore, the court decided that this was the appropriate decision for Mr. Singh as well, even though he didn't admit what he'd done. He was convicted after trial. But in order to allow him to stay in Canada, this was essentially whitewashed away to be a non-serious offense with almost no penalty. In my experience, discharges are generally reserved for truly non-serious offenses that don't involve harm to other individuals, but we can see here how an individual who would not have received a discharge if they were a Canadian citizen did get one because they would be removed from the country. I mean, it seems to me that there's legitimate reasons why an individual will be removed. I mean, they're here as a visitor, he's here to study, and then he's sexually assaulting people. But, I mean, he may be deported anyway. He gets a hearing now rather than just being deported without any hearing in that regard. But I think we can see from these cases that there is race-based sentence in Canada. It's a whole other debate whether that's a good or proper thing, but it is. I think these cases demonstrate that it exists, independent of whether it's a good thing or not. So it's something to consider and be aware of. This video is not legal advice, of course. If you need legal advice, you can contact a lawyer. My contact information is listed below. That's for if you need legal advice. If you want to request a show topic to be discussed or ask something related to the show, please send your email to this email address that's now listed on screen, because I will not respond to Don't Talk TV related questions sent to my law office, because they just don't get to me. Other people monitor that email address, then monitor the Don't Talk TV email address. And if you found this video at all interesting, helpful, or informative, please consider liking, sharing, subscribing, and following us on social media.